John Barlow from Holman, Fenwick, Willan, Middle East will be our speaker, and Mr. Robert Lawrence, partner in Clyde & Co., will head this session. Thank you.
Okay, thank you very much, and good morning everybody, and welcome to the first session of today, which is going back to the sort of traditional marine roots of this conference. Glad to see so many of you here this morning. I think there were some concerns that it would be difficult to drag you out of your beds to come and hear a panelist of lawyers speak to you, so thank you for coming. So this morning's session is going to be looking at the new Insurance Act 2015, and particularly the impact it has from both an underwriting point of view and a claims handling point of view. So just to put this in some sort of context, I think it's quite well known that commerce moves a lot quicker than the law does, particularly from a legislation point of view. And this is a global issue, and the Middle East is certainly exempt from that. A clear indication to me of that was when I relocated from London to Dubai 10 years ago. At the time, the new maritime code was in circulation. Now, 10 years on, this draft in its sixth form is still in circulation and no closer to being published. You may think the London and the UK is different from that, with London being the third largest insurance market in the world. Fact is that it's not, and an example of that is the fact that we have been working with the old Marine Insurance Act 1906 for the last 100 plus years. And luckily, as of last summer, a new Insurance Act was published, for which now regulates the market. And to walk us through that today is John Barlow. John, as we heard earlier, is a partner at Holman, Fenwick, Willan, based in Dubai. John advises insurers and reinsurers of financial institutions in connection with their fidelity, computer crime, D&O, PI, and cyber liability programs, as well as all related claims. John has handled and settled many of the most significant claims to find their way into the London insurance and reinsurance market over the last 2 decades. John now heads up HFW's regulatory team in Dubai, which assists insurers, brokers, and MGAs wishing to establish a presence in the DIFC. John and his team's work includes advising on setups and compliance, and guides clients from the initial approach to the DFSA to obtaining the required licenses. John's a qualified lawyer in England and Wales and is very well placed to talk on the topic today. So please welcome John Barlow.
Thanks, Rob. Right, let's see if we can get this going. Right. Rob mentioned that it's only taken 110 years. 110 years to move from the Marine Insurance Act 1906 to the Insurance Act 2015, but there have been swift developments, rather like if you've ever been in London and waiting for a bus. Typically, you'll wait in the rain for an hour or so, and then 2 or 3 London buses will come along at the same time, all going to the same destination. Now, we've seen that, and we're not just going to touch upon the Insurance Act 2015 and what it means to people who are involved in the London market or have policies subject to English law, but there are other issues which impact not only policyholders in the region, but also in terms of insurers who may be here from London as to what they have to do in terms of underwriting and handling claims. So moving on, I'm just going to touch upon the old law, just to give you some flavour of the egregious cases which have recently come to light, which provide an excellent contrast between the old law and the new law. Possibly the best example is a case called the Galatea. Now, that involved a vessel which had been insured for $13 million. It was destroyed by fire, and underwriters subsequently discovered that its actual value was between $7 and $8 million. And given that the insured had failed to disclose the actual value to the insurers, they were permitted to rescind and avoid the contract. And I'm only going to quote one element of jurisprudence throughout this whole presentation, but it is quite clear that the judge there felt this was a remarkably unfair conclusion to be drawn. And he said the first result in these circumstances would be to treat the insurance as valid in a reduced amount of 8 million euros, actually, not dollars. Such a result will be achieved in cases to which the new Insurance Act 2015 applies when the Act comes into force. Now, unfortunately for the owner of that vessel, his claim fell on the wrong side of the fence. The Insurance Act 2015 hadn't been enacted and wasn't effective at that particular point in time. So the only remedy to the insurers was simply to avoid the policy. Now, that black and white polarisation has hampered any sort of sensible commercial negotiations and outcomes for years and years and years. And that is what the Insurance Act was intended to address. Now, I'm not going to go through the rest of those cases. We're going to come on to versaloot dredging, which involves a fraudulent device in due course, and also the Insurance Act deals with fraud. And we'll come on to sprung and royal insurance when it comes to late payment. Now, late payment isn't actually dealt with within the Insurance Act. It was dealt with within the Enterprise Act. And late payments by insurers from the 4th of May 2017, i.e. about 2 weeks ago, can be recovered from insurers in certain circumstances. So, just giving you some idea as to what we're looking at. The key elements of the Acts are these. The insured has a pre-contractual duty. We're no longer using the terms utmost good faith, but we're talking about the duty of fair presentation. But it does retain the core elements of good faith. So we're not sweeping away the old law in that context. One can still look to that. There's a new requirement for the insured's risk presentation to be reasonably clear and accessible. And that has produced the new phrase of data dumping, by which I mean that the insured says, well, this is all a bit too much, producing all the data, or just to be on the safe side, what we're going to do is just give the insurers all the data we've got, and they can work out how they're going to price it and what they're going to cover. Therefore, there are two limbs in the new Act as to the presentation of the risk. Firstly, the insured discloses all material information it knows or ought to know. Alternatively, the insured may fulfil the duty if it discloses sufficient information to put a prudent insurer on notice that it should ask further questions. So either the insurer does the job of presenting the risk, or it presents enough information to the underwriter for the underwriter to have a red flag or to be put on notice to ask further questions. The second element is knowledge of the insured and the insurer. There's an introduction of a new concept of what an insured ought to know, namely anything that should reasonably have been revealed by a reasonable search of information. Now, this in itself may increase the burden on the insured if, for example, they're looking at the first limb. Alternatively, the insured may say, well, look, we really don't want to go to all that trouble. We'll just find out what information we can, provide it to the insurer, and see what questions they raise themselves. The third issue, remedies for breach of the duty of fair presentation. Avoidance as a sole remedy is now abolished. Avoidance will be available where there's a breach of duty, where there has been a deliberate or recklessness on the part of the insured. If the duty of fair presentation is not deliberate or reckless, the remedy will depend on what the insurer would have done. Now, in those circumstances, it may not have covered the risk, and therefore there still is the ability to avoid the policy. It may have said, well, we'll have covered the risk subject to certain terms and conditions and exclusions, and it can insert those into the policy. And in effect, the policy is rewritten from the outset. And so, by the way, if that policy is rewritten from the outset and they are paid claims which would have actually been excluded because they've rewritten the policyholder will have to repay those claims. Alternatively, they could increase the premium. So those issues about changing the terms and conditions and looking at the premium are cumulative, and there's no, obviously it's early days as to how it's going to be calculated. You're going to have to look at experts, I suspect, more and more in this area to see what they would have done in the circumstances, or what a prudent insurer would have done in the circumstances. And that, in of itself, is an objective test. We then have conditions and warranties. Now, one of the most egregious elements, certainly from an insured's perspective, is a breach of warranty. Now, under English law, if you breach a warranty, it may have no connection with the loss itself, but the insurer is not required to pay. Moreover, a breach of warranty is automatic, and therefore the insurer doesn't have to do anything, doesn't have to give any notice to the poor insured that they're no longer covered. It just happens. So that is no longer a defence to insurers. There are certain formula and mechanics which need to be considered when you're looking at warranties, but certainly it has been diluted. Two further aspects, late payment damages I've mentioned, that is under the Enterprise Act, and also the ability to contract out, and I'll come on to the specifics of that, but there is the ability for insurers to contract out of certain provisions of the Insurance Act. The only one thing they cannot contract out of are basis provisions. And I'll come on to what basis provisions mean and what their impact were, but it's fair to say that the London market for at least half a decade and maybe longer have been removing basis provisions from insurance policies. So the actual impact on that prohibition is going to be relatively small. I'm going to briefly touch upon the Third-Party Rights Against Insurers Act, and as I say, the Enterprise Act 2016, which was enacted, actually it says 4th of May, it's the 14th of May, actually it was the 4th of May, and has now been enacted in relation to late payment. So, what is not in the Act? We've still got damages for late payment of claims has now been dealt with under the Enterprise Act. They are looking at a definition of insurable interest, broker's liability for premium, and requirement for marine policy to be writing sign. Now, those sort of issues are still working their way through the pipeline, but given we've had this sudden run of activity in terms of the Insurance Act and the Enterprise Act, it seems likely that these sort of issues are going to be dealt with pretty quickly. Now, just by way of background, the Law Commission, when it started looking at the Insurance Act, or the issues which found their way into the Insurance Act, they looked at the duty of disclosure. That was the reason why they began looking at it, and they said it's poorly understood. It was difficult for medium and large companies to actually comply with it. Now, I think a lot of these issues have actually been sorted, and they're sort of straw men, these issues. If you look at the difficulty for medium and large companies to comply, if you look at the sole inflexible remedy of avoidance, well, certainly we've seen more and more in the market where you have large companies, you deal with disclosure on the basis of attribution, and therefore you limit disclosure to a few named individuals or people carrying out certain tasks. And it is for them to make the disclosure and for them to make the inquiries. And if there is information held by other people within those companies, that information isn't attributed to the particular individual who's responsible for informing the insurer. And also in terms of the sole inflexible remedy of avoidance, well, increasingly we have seen, probably over the last decade, 2 decades, the idea of innocent non-disclosures. So the duty in relation to the old law, duty to disclose every material circumstance which is known to the insured, and ultimately there is the draconian remedy of avoidance. And this is where you have our esteemed judges saying that some of the conclusions they were forced to draw, either through applying the legislation or applying the case law in a common law context, were particularly unfair to the insureds. So we then moved on to the concept of fair presentation. Now, you're seeing all these thought bubbles surrounding this particular individual, but actually these are all the issues which have to go into looking at the duty of fair presentation. The duty has 4 elements to it. These are: the insured must disclose all material information that they know or ought to know. The disclosure must be made in a way which is reasonably clear and accessible to the prudent insurer. Every material representation of fact must be substantially correct, and every representation of opinion, belief or expectation must be made in good faith. So you still have that underlying thread of a duty of good faith in terms of presenting the information. And it could be argued, for example, if you data dump and you're doing it on the basis that you want to conceal certain information within the data, that might amount to a lack of good faith in presenting the claim to your insurer. So, as I said, what must the insured disclose? Well, any material information which is within his knowledge, that he knows or ought to know, so that the underwriter can price the risk. And as I said, the default position is that, failing that, the insurer gives the insurers sufficient information for them to raise questions about the information which is given. So one is having 2 limbs or 2 options, and they are to some extent mutually exclusive. So you may find in some circumstances the insureds will comply with limb A, and they will provide all the material information which they know or ought to know. Or they may simply say, well, we really don't know what you want, but we're going to give you this information. And what you might start seeing, or rather I expect you'll start seeing, in relation to certain lines of risk and cover, is that you will see protocols developing, and those insurers insuring certain risks will say, well, as a bare minimum, we will require X, Y, and Z. And that is one of the outcomes which the Law Commission saw, that the insurance industry would become far more proactive in asking the right questions rather than relying on the information provided by the insured. Now, in terms of fair presentation, we've got the idea of a material circumstance. On the question of what is material, it is not what the insured considers to be material that matters, but what the prudent insurer will consider to be material when deciding whether or not to underwrite the risk or not. And in those circumstances, that is an objective test. And if there is any dispute about that as to the materiality, inevitably you will have to have some expert giving evidence in an objective sense as to what a prudent underwriter would have expected. So for the expert insurance industry, I think this will be a great fillip for them were disputes to arise. Now, examples of what are or what is material in this context: special or unusual facts relating to the risk, any particular concerns as to why the insured should take out insurance cover for the risk, which is a sort of iterative way of looking at how the question of materiality, and anything which those concerned with the class of insurance and field of activity in question would generally understand as being of something that should be dealt with in a fair presentation. And that's where you get on to carriers starting to look at the risks which they are underwriting and having a more formulaic view and a benchmark series of questions or disclosures required of insureds. A further element is that a disclosure must be made in a manner which would be reasonably clear and accessible to a prudent insurer. Therefore, the insurer, as I said before, can't data dump the information, and there is now, I have to say, people have now contrived to produce a definition of what data dumping involves, which is it can be defined as the practice of simply giving significant amounts of information to the insurer in no particular form, with no structure and no order, in order to argue that the duty of disclosure has been fully complied with. Well, I have to say, I think a lot of insurers have been data dumping for years, and risks have still been written quite satisfactorily. So who must disclose the information to the insurer? Well, let's look at it this way. The insurer is deemed to know any information which is known to him, in other words, actual knowledge, or ought to be known to him, in other words, constructive knowledge, in the ordinary course of business. Therefore, information may be imputed to the insured as well. There are different expectations of knowledge, however, when you look at an insured as an individual or a corporate entity. When the insured is an individual, it is his knowledge which matters. Where the insured is a corporate entity, it's the knowledge of senior managers or other individuals that can make decisions on the company's behalf. In that context, when you start looking at the information which those particular individuals need to seek, they must make reasonable inquiries. Now, in that context, they must make reasonable inquiries of people within their organisation. They must make reasonable inquiries of agents. But also, and by way of one example, if they have contractors who are looking at, for example, they're looking at their cyber risk, they're looking at the integrity of their IT systems. If someone is doing that at a time where they're seeking cover for some sort of electronic liability, it would be remiss of an insured not to inquire of that person, well, is there anything which I should know, which I should disclose to my insurers? The other issue to bear in mind is, as I said before, there is the issue of constructive knowledge, but also it doesn't include confidential information which was acquired by the insured's agent. Now, one issue which has come out of that is a broker used to have a separate duty to disclose information to the insurer. That is no longer the case. The broker's knowledge is attributed to his principal unless the information is confidential and was acquired through a business relationship unconnected to the insurance contract, i.e. from other clients. So, what are the remedies? Well, as I said when I opened, traditionally the insurer could elect to avoid the policy. If there had been a misrepresentation, things have moved on. Where there were innocent misrepresentations, to all intents and purposes, they fell by and by, and the policy would remain on foot. Generally, some policies would have mechanisms for recalibrating the premium, but in those circumstances, the policy wouldn't fall away. But where you have a vanilla policy, for want of a better expression, which simply that there are no innocent non-disclosure provisions, where there is a breach of the duty of utmost good faith, the insurer could avoid. It was elective. They could decide not to avoid, but they still had that defence, and that defence was total. If the non-disclosure was innocent, they could avoid and return the premium. If it was fraudulent, they could avoid and keep the premium. Now, in the new world of the Insurance Act 2015, what we have now is something called a qualifying breach. A qualifying breach can either be deliberate and reckless, or it cannot be deliberate and reckless. Where it's the former, there the insured knew he was in breach of his duty of fair presentation, and he didn't care whether or not he was in breach. Dishonesty or recklessness with regard to the facts is no longer enough. The insured must also know or be reckless with regard to his duty and the breach of that duty. Now, the issue here is that the onus, where you have a deliberate or reckless breach, is on the insurer. And in that regard, you're having to almost prove fraud. And that, as a matter of English law, is very difficult to prove. It's very difficult to allege. And if you get it wrong as an insurer, certainly the cost consequences can be quite considerable. So it actually, it is debatable whether you are going to see allegations made of deliberate or reckless misrepresentations or a breach of the duty, whether you're going to see those if the consequence is that the insurers are going to have a significantly high burden placed on them. Nevertheless, what you might see is that if there's a qualifying breach which is not deliberate or reckless, the insurer has a number of remedies. If the insurer said, well, I wouldn't have entered into the contract anyway, then you can avoid. And I suspect you'll start seeing that really is preserving the original position, because the insurer doesn't actually have to allege fraud or deliberate reckless there. It can simply say, well, I don't believe that there has been intentional recklessness in terms of complying with the duty, but I wouldn't have entered into the contract anyway. What the insurer could also do, I would have entered into the contract on different terms. So in effect, you're rewriting the contract. And as I mentioned before, if you're rewriting it from the start. And therefore, if claims have been paid under the old policy, but if those rewritten terms would have excluded those claims, the insurer can get any sums he's paid to the insured back from the insured. Or the insurer can proportionally reduce the claim by the amount of additional premium he would have charged the insured. And as I said before, those latter two remedies are cumulative. They can decide to change some of the conditions and terms, or they can put up the premium, or they can do both. Now, I would say, whilst that does not expressly set out the position on estoppel and affirmation, If there has been a non-deliberate or reckless breach of the duty, the insurer can do nothing. It can say, okay, well, that's fine. I'm not going to rely on any of these remedies. We're just going to go on as before. Now, I mentioned one of the elements which were, certainly from an insurer's perspective, one of the most egregious areas were the breach of warranties. The Insurance Act does deal with breach of warranties. The old position was that a warranty is a term of an insurance contract which must be complied with exactly whether or not it's material to the risk. So if you breach the warranty, but it has nothing to do with the risk, the policy is automatically terminated as from that breach, and that's the end of it. I won't go into the details. I understand these are going to be put up on the website afterwards, but in essence, that is the old position. So what is the new position? Well, firstly, basis clauses. Basis clauses, pre-contractual representations, cannot be converted into warranties on the basis of a term in the policy or in the proposal. So what normally used to occur was that you would complete the proposal form, that proposal form would be incorporated into the policy, and everything which is stated within the proposal form would in effect be a warranty for the purpose of the policy. So if, for example, there was anything within that proposal form which was a warranty, and that warranty, they were in breach of that particular warranty at the inception of the policy would fall away immediately it incepted. Basis provisions are now gone. As I said, basis provisions have been removed probably for a decade or so. They are included still in policies which we see in the region because people are still using old policy wordings. But nevertheless, as a matter of English law, basis provisions are now history. The other part of how the Insurance Act deals with basis provisions, rather warranties, is that if you have a warranty and you breach it, what happens is that the policy or the coverage is in effect suspended for that period of breach. So, for example, if you're required to maintain a burglar alarm on a premise, and after 6 months within a 12-month policy, the burglar alarm fails, and it takes you a month to get it repaired, well, within that month, you won't be covered. But prior to that breach of the warranty, you'll be covered, and when the burglar alarm is mended, you'll be covered. Now, there is some uncertainty as to what happens where you might have an insured who would like to play the system and thinks, well, I see this warranty, it may be quite expensive to comply with it, so I'll comply with it off and on, and it might save me a bit of money. And in those circumstances, I think a court may be slightly less sympathetic to insured which tries to play the system when it comes to breaches of warranties. The Act, however, does let me just get back. The Act, however, does note that there may be some warranties which are breached which simply cannot be rectified. And in those circumstances, a breach of warranty has exactly the same impact as it has before. If you cannot rectify the situation, well, that's the end of it. And by the way, just just taking a step back in terms of basis clauses, whilst they may be now prohibited, there is nothing to prevent insurers, if there are certain elements which are contained in the proposal form, certain representations, certain warranties contained in the proposal form, there's nothing to prevent insurers from incorporating those specifically into the policy wording. You just cannot have a catch-all basis clause. So you'll have to look carefully at each representation, and at any warranty which you want to incorporate into the policy will have to be specifically incorporated. We're now getting off time. I'm going to briefly touch upon fraudulent claims. The situation on fraudulent claims is that the insurer is not liable to pay the claim, and that applies to the entire claim, even though there may be parts which are genuine. The only thing I'm going to say about fraudulent claims is the idea of a fraudulent device. This has nothing to do with the Insurance Act 2015, but has to do with a 2016 case called the Versely Dredging, which is the Merwestone case. And there, this was a case which went to the Supreme Court. There, the court held that where you were using a document which, in effect, contained a collateral lie in it, in support of a claim where you had a genuine claim, there the court held that that would not preclude the insurer from making cover, from obtaining cover in those circumstances. I quickly want to say, and I know time is moving on, I quickly want to say something about the Enterprise Act 2016, because I think this may have a quite significant impact, and I suspect it will quite often be used by insureds to really try and extract some cash from insurers as quickly as possible. And it is this. Under English law, until the Enterprise Act came in, insurers could not obtain damage for late payment of any indemnity under an insurance policy. And it worked on the basis, the analysis was, when a claim occurs, it gives rise to, there is in effect a breach of contract between the insurer and the insured. That gives rise to damages, and under English law you can't get damages on damages. What the insured could get was interest on the damages, but it couldn't get damages. What the Enterprise Act sought to do was to say, well, if you, the insurer, delay in making payment, that can give rise to a claim in damages. And so the insured would be entitled to its indemnity, it would be entitled to interest, and it would be entitled to damages. Now, this is an implied term into a contract of insurance. It can be excluded in business contracts, but not in consumer contracts. What constitutes a reasonable time is not defined, and no doubt that will result in litigation in due course. The Act provides a non-exhaustive list of factors to be considered: the type of insurance, the size and complexity of the claim, any statutory or regulatory issues which have to be taken into account, and other practical factors, as they point out. For example, claims made over the Christmas period may take some time to get paid, or, for example, if there is a large major systemic loss, which requires the insurer to have a considerable number of people handling the claims. The insurer has a defence to this, and bear in mind, with these sorts of programs, quite often you'll have TPAs involved, and if the TPAs mishandle the claims, then the insurer may have a claim over against the TPA. The other issue also is that if there has been a delay, the insurer may want to say, well, it was actually quite a complex claim, there were quite a lot of legal issues involved, and therefore the insurer may say, well, look, here's the legal advice we've received. Now that may lead to further issues revolving around waiver of privilege, and the suggestion is that you have in your insurance policies a specific clause dealing with these particular issues where there is late payment, that if you need to show that you are reasonable in treating the matter, you may want to disclose legal advice in those circumstances, but there is not to be a waiver of privilege. As I said, what you can do, you can contract out of these clauses, not for the purpose of consumer contracts, but if you're contracting out you need to be quite specific and point out and highlight to the insured that you are contracting out, what clauses you are contracting out of, and the meaning and effect of those contracting clauses must be clear and unambiguous. And I think that, at the moment, certainly from our perspective, is where we're going to see insurers coming under considerable attack when it comes to handling and late payment of claims. Now, I appreciate we've only got about 6 minutes more of this session, so I'm going to wrap up now and hand back to Rob.
Thanks very much. Okay, so I think similar to yesterday, we're going to have both presentations back to back and then open up for Q&A at the end. So I'll hand over to Yaman.
Thank you. Good morning again. Our second session will be today about vessel arrest and P&I clubs, letter of undertaking. Our distinguished speaker today is also Yaman Hawamdeh from the same distinguished law firm as well, Holman, Fenwick, and Willan. Yaman is a highly registered and regarded lawyer as a shipping law in the region. His practice focus on regional shipping dispute and litigation. Also, he's also specialized in civil and commercial disputes. Actually, his CV is extremely long and very interesting. As you can see, it's on the screens, and it's also in the website. So I would like just to give you more time at the speech to give you. Yaman is extremely very distinguished, and it will gonna take very long time to read his CV. So please, Yaman, we are so lucky to have you with us. Thank you very much, Yaman. Thank you.
Thank you, Maher. Good morning, all.
Most importantly, he's a Jordanian.
Good morning, all. I was asked to speak about ship arrest, which is basically a bit relevant to what John and Rob was talking about in terms of claims, in terms of recovery. And we'll be talking about distinguishing ship arrest as a mean of security with other means of security toward the end. Just quickly on the agenda, so we'll be defining what is a ship arrest. We'll be talking about where this right comes from. We'll be talking about the requirements. We'll be talking about jurisdiction issues, which always arise. So where can you exercise that right, in which country, in which jurisdiction? We'll be talking about arrest of sister vessels, which is, again, another mean of security. And I will be focusing about the Middle East, where it's possible to arrest and how easy is it, what are the requirements, and giving you a brief procedures in relation to that. We'll be also talking very briefly about any liability for wrongful arrest. So if you arrest a vessel and it turns out that your arrest was wrongful, and as I said, other means of security. So what is a ship arrest? It's a detention or a restriction or removal of a ship by an order of a court to secure a maritime claim. And there is lots of misunderstanding in relation to ship arrest. So it's not a seizure or a way to execute judgments, whereby, for example, if you have a judgment or if you have an award and you want to execute against the assets of your opponent, your defendant, you will go and execute that judgment against that vessel. When you do that, this is not it doesn't come in the context of ship arrest, in the context of security. because that award can only be executed against the ship owner, while a ship arrest, it's a concept which have been developed through years and years of shipping practice, where suppliers, claimants were unable to identify the owners of a ship, and therefore the concept had developed into allowing these claimants to arrest the vessel herself, to make their claim, to take an action against the vessel herself. So basically, this is what we call a legal term as action in rem. So it's an action against a thing. It's not against a person or a party or a company. It's against the vessel herself. What does that action enable the creditor? It enables him, obviously, in theory, to obtain his security. So basically, he's saying, you are under arrest. I want an order to put this vessel under arrest until actually this defendant or the vessel herself gives out another mean of security. But in practice, it's used beyond that. It's used sometimes to pressure the owners or pressure the ship operators to come to the table to settle, to deal with the claim immediately rather than leave it later on. So it's used as a tactical move in lots of times. It's also used to bring jurisdiction in some cases. So where, for example, you're shopping for a jurisdiction, you have a claim, and it's for example, Jordanian courts or Kuwaiti courts do not have jurisdiction to hear that claim. There is certain circumstances where if you are able to arrest that vessel in Jordan or in Kuwait, it will, by default, it will bring jurisdiction to the local courts to hear the underlying claim. So it's used as well for that purpose. And as well, it's sometimes used, again, as a tactic in order to enforce that vessel to be sold through judicial sale, though yet your claim is not yet crystallized. So if you have a vessel and distressed owner or operators who are joining basically in debts, but they are still operating their vessel, she's incurring more and more liabilities, more and more claims. So the claimants, the creditors on the list, would want to stop that operator from operating his vessel and incurring more liabilities on that vessel, which would undermine their security. So what they do, they would go arrest and then try to get a judicial sale, get her sold, and the money is deposited in court or in other means in order to stop the vessel from incurring more liabilities. So where this right comes from? It comes from three currently what we see in the market comes from three legislations. Most of what we use, most of the arrests which we exercise in the region, within the Middle East region, we use the third point here, the national legislations. So lots of the Middle East countries will have typically a maritime code, and these maritime codes will include a section dealing with ship arrest. We'll come to that later, talking specifically about Jordan, Lebanon, GCC countries, and so on. The other source of that right, it comes from an arrest convention in 1952. And this is a widely adopted convention. It's basically, it unifies the rules of ship arrest. There is a new convention, relatively new, 1999, which came into force just in 2014. It's a new convention. It's relatively, currently it has a limited impact in the market because the signatories to that convention, they are listed there, down there. It's not basically widely adopted yet by countries. But what's interesting in that new convention to you as underwriters, as insurers, is that it expanded the categories of maritime claims, and we will come to that, defining what is a maritime claim, but to include premium, insurance premium on vessels, allowing underwriters to actually arrest and secure their claim for these premiums by arresting the vessel. And this is a common question which we are regularly asked: can we arrest for outstanding premiums or not? So what we have said an arrest is a detention or restriction of a movement of a vessel by a court order against a maritime claim, or to secure a maritime claim. And maritime claims, the definition, what is a maritime claim? It varies from one legislation to another. But they are mostly, if we're talking about the region, they are mostly adopting the 1952 convention, with maybe most of these points here are covered in local legislation. So any damage caused by the vessel, by the ship, to any third party, whether individuals, whether property. So jetty damage, dock damage, crane damage. If you are a property insurer and you're insuring a port, facilities, the docks, any damage to that docks will allow your assured or you as a subrogated insurer to arrest the vessel for your claim. Salvage, any disputes under charter parties, any disputes under bills of lading. So if you're a cargo marine insurer, it will and it will allow your assured again to arrest for any cargo damage, general avalanche, pilotage, and so on. What is here mostly relevant to you probably is property, is any damage to property, probably, and goods. So what is required to arrest? As we said, you need to have a basic requirement. You need to have a maritime claim. So you need to qualify under one of these listed claims to get an arrest. And the court where you're applying to arrest will need to have jurisdiction to look into your application. And a common question, which is, again, we are usually asked is, can I arrest if my claim is against, for example, a charterer or against an operator of a vessel and not against the owner? And this is where it becomes different between a ship arrest and other attachment application, what is known here, for example, in Jordan, بالحز التحفظي. This is where the distinguish come from. So, for example, you have a claimant and you have a head owner of a vessel who bareboat charter there to someone else, and that someone else, the charterer, he appointed the crew, he's operating the vessel, and that vessel caused, for example, a dock damage or damage to a crane. So basically, your claim as a claimant or as a property insurer is against the charterer or against the master who was negligent. Can you arrest the vessel despite the fact that actually your claim is against the charterer? And the answer to that is yes. So you have a right to arrest, and this is whether it in most common law, international, under the arrest convention or under the local legislations in the region, it will give you that right. But the question is, after you arrest, you bring your action. Your action will be against the charterers. So can you actually enforce that judgment against the vessel while that charterer does not own the vessel? And this is creating a huge debate in the region, especially after, I don't know if you heard about OW Bunkers, a big Danish bunker suppliers who collapsed a couple of years ago. Hanjin Line, for example, who probably you all know. These two big collapses have created substantial amounts of ship arrests in the region. And most of these arrests were targeting ships which were not owned by OW Bunkers, but bunkers were supplied on account of OW. or they were targeting ships which were chartered by Hanjin. So Hanjin was, for example, operating, I think, something like 110 vessels, and about 80 were chartered. They didn't own it. And once they collapsed, creditors started looking to these vessels, which were chartered by Hanjin, to arrest them. And the answer is, so far, what I've seen in the entire region, courts have not landed into a specific outcome. My own opinion that it is possible to enforce a judgment against a charterer, against a vessel which does not belong to him, when there is actually a priority right, or when your claim qualify as having priority over that vessel. So we've said two requirements. You need to have a maritime claim and you need to have jurisdiction. So if you're targeting to arrest in Jordan, the question is always, do Jordanian courts have jurisdiction to arrest or not? And in most countries within the region, the fact that the vessel is in that state or in that country on its own will give jurisdiction to local courts to look into the arrest application. So in most countries, wherever that vessel go in the region, every port she calls, local courts there will have jurisdiction to look into the arrest application and to hear your arrest application. Of course, this doesn't mean that that court will have also jurisdiction to hear the underlying claim. For example, if you have a dock damage which happened in Jebel Ali and then in Dubai, and then the vessel proceeded to Kuwait, and you want to arrest in Kuwait, you arrest in Kuwait. It doesn't mean that Kuwaiti courts will have jurisdiction to hear the underlying claim, what you're claiming in the vessel. So what do you need to do is you can arrest, and following the arrest, you need to bring your substantive action in the correct form and in the correct jurisdiction. So if your action was, if you were, for example, trying to recover an insurance claim which you've paid under a bill of lading, so you look at the law and jurisdiction under that bill of lading. If it calls for English arbitration, then you need immediately to commence English arbitration. And you need to show the local court that you have jurisdiction to arrest, I've obtained my arrest order, and here is my evidence that I've commenced arbitration in the UK under the contract, and I want you to keep that arrest until I finish my case or arbitration in the right form and jurisdiction. Arrest of sister ships, and this is again, it's a common question which we are asked, and the local laws within the region, its position in relation to sister ship arrest is a bit different than the arrest convention. So the arrest convention says that you can arrest any sister ship, any ship in respect of which a maritime claim arose, or any other ship owned by the person who was, at the time when the maritime claim arose, the owner of the particular ship. So if, for example, you have a claim against the owner of the vessel X, you can arrest that vessel or any vessel owned by the same owner. This is not helpful where your claim is not against the owner, when your claim is against a charterer. In that instant, this is where local legislation come in place, and it allows you to arrest any vessel owned by the charterer. So some charterer, again, like Hanjin, they owned some vessels and they operated other vessels. So these operated vessels, you can arrest them because they are related to your claim when they are related to your claim, or you can arrest any other vessel owned by Hanjin itself. Not operated by Hanjin, owned by Hanjin. Release. So how can a vessel be released? The general rule say that Of course, it can be settled if the claim it can be released if the claim is settled, and this is what we see so often. Probably 90%, let's say 2 years back, not in the recent current market, but 2 years back, we probably above 90%. Every time there is an arrest, a claim will be settled amicably after that. But also, the vessel can be released against a security. A satisfactory form, in satisfactory form and sufficient form. And usually courts will determine that satisfactory security. In the region, courts will only accept cash, and this is what, when our clients' ships are arrested in the region, we literally pay to the court in cash because this is the quickest way, or against a bank guarantee, which is not very practical because it takes sometimes weeks to get it in place. P&I clubs' letters of undertaking or other forms of letters of undertaking by other insurers other than P&I clubs are usually not recognized by local courts. So they will come to them, but usually the courts will say, no, it's bank guarantee or bring cash to the court. So we'll talk about the Middle East briefly. We'll talk about the theory and the practice, what's happening. Now, in theory, you have national laws of Kuwait, UAE, Bahrain, Qatar, and Oman. They recognize the right to arrest, and they recognize maritime claims. You can arrest under these laws if you have a maritime claim. Vessels being in any of these countries will give local courts the right to arrest. As we said, in terms of jurisdiction, it is a very powerful tool. In practice, we see it because all of these countries, except for Kuwait and Qatar, and we'll get to that, the local courts will demand cash or bank guarantee to release the vessel. The third way to get her release is by filing something called the grievance, which takes weeks to be heard, and therefore it's not practical. Now, Jordan, Iraq, and Lebanon, their maritime code do not specifically deal with ship arrest in the same way as the other countries. And usually in these countries, when an arrest is attempted on the basis of attachment application under the general rules which governs the attachment of assets. And as I said, these are a bit different because the requirements to attach under these rules are different. They will ask you to prove that actually you have a good case. It will ask you to show that actually there is a risk of dissipation of assets. If your defendants were local, the court might say, no, I'm not allowing you this because your defendant is local, so what is the urgency? Go file your case, get your judgment, and then enforce it against your opponent. If anyone here who have tried already, I've tried it definitely in Jordan. The most recent one was a couple of months ago. It didn't work out. But in Iraq and Lebanon, if you have any experience, please share it at the questions section. Now, in practice, ship arrest is very possible and common in the UAE, Bahrain, and India. We see it all the time. It's easy, it's common, courts are used to it, it's doable. It's possible in Oman, Jordan, Iraq, and Lebanon. Again, I had a couple of bad experiences in Jordan, but also we had successful application years back. But we call these jurisdiction non-friendly jurisdiction to arrest because there is no stable, consistent practice. So sometimes it works, sometimes not. Sometimes the local lawyers will ask you to substantiate things which are not required actually under ship arrest procedure. It's not possible currently in Kuwait or in Qatar. and probably it's because of orders given by the port authorities or the government to court saying that these ship arrests are creating problems at the port and so on. It's not happening. Now, what are the procedures? So practical procedure, most of you who deals with claims probably would know that you will need a power of attorney, you need to translate the documents, you need to put up fees, you need to put a counter security. And counter security, it's a security, it's a payment, or it's an undertaking which is made by the claimant or the applicant to secure two things. Sometimes any damages sustained by the ship owner for a wrongful arrest, and sometimes it's made to cover what is called the expenses for running the ship if the owners disappear. For example, in Australia, I arrested there, and we were asked, once we arrested, we were asked immediately to post $50,000 US to the harbor master. We posted in order to cover any bunkers, to cover any crew wages, so effectively you as an applicant will become as if you were operating the vessel, and you need to ensure that she's operating, she remains seaworthy, and she's not dumped. So, and after 2 weeks, he will ask you for more money. He'll say, I have to pay this, pay more. And the owners will step back. They can't step back and say, I'm leaving my vessel, you pay for everything. So the counter security, this is the purpose of it. In the region, the counter security, whether it's required or not, it depends where. Even, for example, in my 12 years doing shipping litigation within the region, I've never seen a wrongful arrest claim. People threat that they will do it. So if you're a claimant, once you arrest, you'll find the owner jumping around, saying, I'm going to sue you, I'm going to claim all these loss of hire, I'm incurring everything. They never do it in practice, simply because after litigating 2 to 3 years in court, people will be really frustrated with paying lawyers' fees and with running the case in court. They will not go into another claim. Again, if you had any experience, wrongful arrest cases, please share it with us. But usually we say it's the fact, even if you arrest and even if your claim failed, it doesn't mean that actually your arrest was wrongful. It doesn't trigger liability immediately for wrongful arrest. The claimant, or the ship owner in this case, or the operator, will need to show bad faith, will need to show that actually the arrest was not justified. And as I said, because the maritime codes in the region are very clear on defining what is a maritime claim, and it gives you the right to arrest for a maritime claim, any wrongful arrest claim is difficult. Other forms of securities. Once you arrest, probably the owners will come, depending on the nature of your claim. The P&I, the owner's P&I will come and offer a club's letter of undertaking. Now, what you need to know that in the region, again, courts do not recognize this. So unless you accept it as a claimant, the courts will not accept it. And it's basically, what is it, for those who are not familiar with it? It's an undertaking from a financially strong organization saying to the claimant, I will pay you on certain terms if in consideration of you not releasing this vessel and not trying to arrest her again. And what you usually you need to look at as an insurer in a club's letter of undertaking, you need to look at the payment term, law and jurisdiction. And this is different than the law and jurisdiction in the letter itself. So, for example, the letter will say, I will pay you if you get a judgment, a final judgment, by X court by English courts, or from or an arbitration award in this form in Singapore, or so you need to look at that. This is very important. Are you happy with the form or not? This is a key issue. Or you want to keep it open, for example. Think maybe you haven't actually looked into the law and jurisdiction of your claim. So you want to say, oh, shall I bring it in Jordan or shall I go to the UK? So you can actually say, the letter can say, I will pay you if you obtain a judgment or final arbitration award from a competent court. So it will cover everything. The term of payment, how long it will take the club to pay you following you obtaining that final award or judgment. And then there is the law and jurisdiction of the letter itself. And this is something which is, again, misunderstood a lot in the region. So sometimes when I'm acting for clubs, I'm dealing with the local claimant, he will come and say, no, the law and jurisdiction, I want it to be local. I want it, for example, Qatar courts and Qatari laws. And we say, okay, that's fine, up to you. Because this letter of undertaking is a contract. If the claimant obtain the requirements under that letter and present a claim to the club, and the club say, I'm not paying, you need to sue the club. How do you sue it? Do you want to really sue it in Qatar, or do you want to sue it back in the UK? So it's always better to follow the law and jurisdiction clause where that club is. And usually most IG clubs will have presence in the UK, and their standard form will include English law and English jurisdiction. So I would recommend you keep this as it is. Another thing is undertaking to appoint lawyers to accept service. And this is another problem which we see that, for example, you get your arrest, you get your letter of undertaking, the vessel leaves, and then you instruct your lawyers, they go to the court, they file their case in court, and then they struggle to serve your opponent, the ship owner or ship operator, because they are abroad. This is unless, of course, jurisdiction where agent can accept service. So you want an undertaking and warranty from the club that actually we will instruct lawyer to accept service within 14 days of you notifying us of the claim. Another form of guarantees, and this is the last one, is bank guarantees. I spoke about this 2 years back. It's really, it is challenging. We see vessels being delayed for weeks until a bank guarantee is arranged. I'll always say that a good terms club letter of undertaking is much better than a bank guarantee. And from experience, I know some of you will not agree with this. From my experience, practical experience, this is my view that a club's letter, especially if it's coming from a big insurer, it will be better. This is it for me. We're going to take some questions, so thank you so much.
Thank you, Yaman. Thank you very much for this interesting lecture. I just want to say a few words very quickly before we take any questions. As Yaman said, that although the Jordanian Maritime Act, which is the same act as in Lebanon and Syria, by the way, same wording, although do not specify any special articles on vessel arrests in Jordan or Syria or Lebanon, but I can say from personal experience that it's not as difficult as it looks. So if you have the needed documents, and the most challenging documents is the power of attorney if your client is not in Jordan, because the power of attorney must be legalized up to the Jordanian embassy, for example, and it must be shipped or must be sent to Jordan and then translated to English if it's not in Arabic, and then submitted to the court, since the court do not accept any documents whatsoever unless they are translated. So if you have the needed documents, the needed documents for the claim. The claim, it's not difficult, Yamin, because you only have to prove damages. As you all know, transportation contracts in general, whether by vessels, by airplane, by train, by land, it's what we called is a presumed liability. And it's so much difference between the presumed liability and the negligence liability, i.e. the presumed liability which applies for all the transportation contracts. The carrier or the actual carrier is responsible unless otherwise. So basically, if you if you have a clean bill of lading, what we called, or even if you have a bill of lading with remarks, and therefore the goods arrived at the final destination damaged, or the damages is not specified in the bill of lading as in the remarks, generally speaking, now I don't want to go into specific, but generally speaking, the only thing that you have to prove to the court is that the goods arrived damaged or in a shortage, and this can be done very easily. The only thing you have to do is that you have to ask the court to appoint a loss adjuster, and the loss adjuster will go and see the goods on the vessel and send his report, which can be done within hours, if it's possible, of course. Once you submit this report to the court, then you can arrest the vessel immediately. And I can say that from our personal previous experience and through our family law firm, lately we managed to arrest so many vessels in Aqaba for the last few years. Now, the only thing is that in Aqaba, due to the size of the port of Aqaba, generally speaking, the court are really restrict vessel arrest, especially when the vessels are old. Because the only reason for that is that when we have an old vessel, unfortunately we don't have a good P&I club, and therefore the owner of the vessel, of course, will not be able to submit to the court any form of guarantee that will allow the vessel to sail after that. So if the vessel is new, or if we can convince the judge before we have the claim that there is a good P&I club, and that the P&I club will be able to submit a bank guarantee in order to release the vessel, that makes it much easier for us to convince the judge to grant us an arrest. But if the vessel is old, then it will be a difficult job to convince the judge to have the arrest. Now, if we have any question, we would like to take it. If we can start with you first, please.
Yes. I'll probably start off the session by asking John a question about the Insurance Act. Okay. Yeah, so just going back to John's presentation on the Insurance Act, I was just wondering, John, ultimately, what do you think the impact of the Insurance Act will be on the London market and wider? And I say that in the context of the opt-out provisions. Do you think we'll see insurers relying on the opt-out provisions more so? I think the P&I clubs have already expressed their intent to use that provision to opt out of certain provisions, and I was just wondering how applicable it will be in the current soft market as it is. I mean, will brokers and the assureds require or prevent insurers from using the opt-out provisions?
Well, I think certainly in the marine context, and you're right, the P&I market have already made it clear that they are going to apply the opt-out provisions, but simply opting out isn't going to be enough. There are transparency under Section 17. There are transparency provisions, and if they're going to opt out, they need to articulate what they're opting out of. They can't have a blanket opt-out. Secondly, they can't opt out of the basis provisions. Thirdly, in a soft market, which is driven by the brokers, Trying to opt out, I think, is going to be difficult as well. But bear in mind the obligations. I think you're going to see efficiencies brought in because, and also a greater certainty, because if there is going to be compliance, you're going to see the insureds having to be more, have to apply themselves when presenting the risk, and likewise underwriters are going to look at the risk more carefully. And as I said, you're going to see across classes of business certain groups of underwriters say this is the minimum benchmark information we're going to have. But as I say, you're quite right. Certainly in the marine market, they are looking at the opt-out provisions. And we'll just have to wait and see. That's really all we can say at the moment. But I think it's going to be an interesting dynamic. I think all the parties are going to have to work a lot harder, but in doing so, you're going to have more certainty, more efficient risk transfer, more efficient pricing of products as well.
Okay, good. And the second point, which I find quite interesting, is in relation to the warranties, and where now there needs to be a causative link when there's a breach. And to some extent, there's an argument that the English market has finally caught up with the Middle East, because in many jurisdictions in the Middle East, a breach of a warranty is not necessary enough to avoid cover. There needs to be a causative link. So just going back to the Insurance Act and the bit about the warranty is about the suspension, that if there is a breach of a warranty during the term of the policy, then cover is suspended. If there was a loss during that period that was not caused by the breach of warranty, is that still covered?
Yes. Sorry, I mean, we didn't go into details, but if the warranty has no connection with the underlying cause, then there's a catch-all provision under Section 11 that will not preclude the insurer, or rather the insured, claiming under the policy. It is simply where there is a causative connection between the breach of the warranty and the suspension. There are circumstances where, if they are connected, you won't have cover during the suspended period. But where there is no connection, under Section 11, where there's no connection, the insurers will not be able to rely on the breach of warranty or the condition precedent and such like.
Okay. I'll take this opportunity to open up to the floor for any questions. Anyone have questions on the Insurance Act? So if we can have a microphone over there, please.
Khalid Abu Nahal from Trust. Thank you very much for the two presentations. They are relating to legal terms and laws, which I see the most difficult, especially when it goes to interpreting words. Interesting about the new enactments in the UK relating to insurance and affecting principles of insurance that has our industry is built on through so many years in the past. And with the new acts affecting the duties of the insured and the way it releases some of the restrictions on them, the decision is maybe easy to enact, but the implementation of the acts and the words, the meaning of the words relating to previous precedences is going to take some time. Also, the impact of these changes on the cost of claims, and accordingly the pricing of the risks during this new era. When we relate previous claims, we may not be able to simulate or adjust the claims to take effect, the impact of the changes. This is one of the challenges. especially in a very competitive environment. Second part of my, of course, I need your comments on this. Also, the second part of my question is how this going to impact our region and relating to, first, the original policyholder reinsurance contracts with the reinsurers. Thank you very much.
Can I first say something as to how it might or might not impact this region? Increasingly, obviously, policies issued by local carriers are subject to local law, and the Insurance Act has no impact whatsoever. Increasingly, and certainly I've seen it, I don't know, Rob, if you've seen it as well, and don't know whether everyone here has seen this, increasingly, reinsurance contracts are subject to local law and jurisdiction, because the brokers have got it into their minds that the policies should be back to back, and therefore the Insurance Act may not impact there. It obviously impacts where you have, for example, a facultative reinsurance contract between a cedent in the region and with London. There will be an impact there, and there are a number of impacts. When you're looking at late payment of claims, you have a subscription market. Some reinsurers pay in a more timely fashion than others, and there may be risks which arise there. The other thing is, when talking about pricing and talking about how the Insurance Act impacts policies, you have exactly the same issues here. If, for example, you look at the UAE and you look at, we see this time and time again, where you look at policies which are issued, and they're issued because when you look at the product, it has certain terms, it has certain exclusions. Whether those exclusions work as a matter of UAE law is always debatable, certainly in a UAE court. So there are a number of variables here. The impact of the Insurance Act will obviously impact carriers here who have a connection with the London market, with the English jurisdiction, and those reinsurance contracts are subject to English law. Other than that, it's difficult to see how it is going to impact. More so on the marine side, where there is that element of the direct connectivity to the English market. And that is where you are going to see, I suspect, a significant amount of changing in the landscape in terms of how warranties are worked, whether you're going to contract out, whether there's going to be a late payment. Those sort of issues I suspect you are going to see in the marine market, less so, I think, in the sort of facultative non-marine market.
Yeah, I agree with John. The impact is probably going to be relatively limited in the Middle East. And I say that for a couple of points. Again, John said that primarily direct cover at the direct level will not be subject to English law. It will be the local law of that governing jurisdiction. On the odd occasions where you do find actually English law is incorporated into those policies, then on most occasions, if the claim is heard before the local courts, then the local courts will typically strike through that English law provision and apply the local law, and that's especially so in the UAE, where by default they're allowed to do that. I guess possibly the one exception might be in Saudi Arabia. So if, for example, you had a direct policy there that was subject to Saudi law and jurisdiction, yet that policy incorporated standard institute clauses, whether it was hull or cargo, and there was a dispute over, a claim arose in relation to the institute wording, then there's a chance that English law might apply, because actually Saudi Arabia is actually probably the most advanced jurisdiction in the Middle East when it comes to handling insurance claims. And I say that because the new regulations that allow the SAMA Insurance Dispute Committee to apply comparative jurisprudence. So in your typical institute wording where it says English law and practice at the bottom, if the laws of Saudi Arabia are silent on a particular issue under insurance law, then the Insurance Dispute Committee is entitled to look for guidance to the English courts, and so in that way there may have future impact of the Insurance Act within the kingdom. But that's probably at the moment the only sort of real exception within the Middle East. Are there any more questions from the floor? Yes.
Can I just raise one important point when it comes to the Jordanian maritime claims? In the recent amendment for the Jordanian maritime claims, there was a new act or a new article adopted in the maritime claims stating very clearly that any condition, whether it's in the charter party or in the bill of lading, stating other jurisdiction than Jordanian law. Now I'm talking about anything that related to Jordan from outside. This condition is considered to be null and void. So the Jordanian jurisdiction, in these cases, reveal for any other articles, whether even it is in the charter party or even in the bill of lading itself.
Hi, I'm Daniela Elias from Elias & Co. I was just wondering, on the topic of fraudulent claims, obviously you've said that there's no statutory definition. Don't you think that, considering the whole purpose of the rules against fraudulent claims is to deter fraud, that by having a statutory definition it would actually assist a lot more in deterrence?
Yes, I think it would, but I think ultimately fraud has a number of colourings to it, there is a spectrum of fraud. We talk about whether it's deliberate or reckless, going back to many years ago when you started talking about intent in criminal law, and you talk about recklessness and the various stages, the sort of colourings of recklessness as well. It's very difficult. I mean, what they have tried to do, for example, is maybe not looking at fraud, but having a definition of dishonesty, and trying to import that, because if you look at various criminal statutes in the United Kingdom, say the Theft Act 1968, they look at how you define that sort of activity. But certainly having a definition of fraud would be helpful. Whether you could expand it or contract it to maybe a definition of dishonesty, it is very difficult. There are, as I said, there are spectrums. You may have an intent, or it may be a deliberate fraud, or it may be you simply, you know you're doing something wrong, but you don't really care about it. Sort of loss of moral compass. So yeah, it would be very helpful to have that. But bear in mind, I think from a practical context, if you look at Section 8 and the remedies which were available, where you have a deliberate or reckless act, underwriters can avoid. Now they will think certainly under English law, they will look very carefully to think, well, do we want to allege something which is tantamount to fraud? And I think underwriters, unless there is absolute evidence, are very, very reluctant to allege that. I think in circumstances where they can say, well, look, it's not necessarily deliberate or reckless, but we can still avoid because we wouldn't have insured the risk anyway. So there's a sort of way out for underwriters there. But yeah, I entirely take your point. Having a definition of fraud would be very helpful.
Sorry, do you think that following all of this reform that's happening in the Insurance Act, that they will see that there is a gap on fraudulent claims, so that we could possibly see further reform and statute for fraud, or not?
Well, I mean, there clearly is a gap because fraud isn't defined. Whether they've got the wherewithal to do it, given we've just had the Insurance Act, the Enterprise Act, the third-party rights against insurers, whether, I think they might move on to something else. It's probably not top of their agenda at the moment, but you're quite right, it's undefined at the moment, and I think it would be helpful to have something, whether we're going to see it, given they've applied themselves to the insurance industry. The government has given the insurance industry a fair bit of time, and they probably want to move on.
Max, please.
Thank you very much. I will call you John. Thank you very much for all the information you gave us. And as you said, it's a very soft market, and we don't make any money anymore in cargo insurance. So we are very happy to know where we can stand not to pay a claim. Unfortunately, our clients, if they know what we have discussed today, they will come and say, okay, but how can we be insured, whatever is the situation? They will ask us to add a clause saying the insurer has got all the information regarding the marine shipment, and therefore there will be no exclusion or no reason for not paying claims. Have you been confronted with such a situation? Thank you.
Firstly, thank you for that question. Firstly, it's interesting. I've seen at various conferences people talking about the soft market. I think they talk about a soft market on the hope that it's cyclical, then it'll become a hard market. I mean, I think one might want to accept it is a market now, and it is what it is. Yes, I've certainly seen those clauses where they say we've given you all the information, we've satisfied our duty of disclosure, and that's the end of it. Other carriers, insureds, deal with it in different ways. They, for example, they have nominated individuals within the companies, or they have nominated officers who perform certain roles, and they provide the information. Anyone else, if they have any knowledge, it is not going to be attributed to that particular individual or that particular insured. But yes, I've certainly seen those clauses, particularly on the sort of trade credit, trade finance side, where you have banks involved, and therefore there is that. They have a significant degree of leverage because on a lot of these programs they're buying a lot of this cover, and that is what the brokers are happy to put forward on behalf of their clients, and that is what insurers are happy to accept.
Vessel arrest. Any questions for?
I think we have one over.
Yeah, Ziad.
Hi, this is Ziad Najum. Hello, Yaman. We're happy to have you, and thank you very much for your nice presentation. One question. You say that you prefer to have a good LOU than a bank guarantee. Can we know the reasons of this?
It's basically cost and mitigation of losses. They are both security, just as good. And an LOU, which is coming from an international group, P&I club, or those underwriters who have actually now running a fixed premium P&I cover, it's just as good as a bank guarantee. The bank guarantee will say we will pay if you satisfy these conditions, and an LOU will say the same. In fact, I think P&I clubs, they act less commercially than banks as well. So when a bank actually gives a bank guarantee, usually, of course, banks will give only a bank guarantee when they have the cash from their customer who have asked for that bank guarantee to be issued. But for any reason that cash was not there, you will find the bank trying actually to avoid his liability under the bank guarantee, while in a normal P&I market, the reserve will be taken. They are financially strong, and they will not try to avoid liability. They will just, if you satisfy the term. And I don't know, maybe Rob had seen examples more, but I've never seen an IG club saying, sorry, we're not paying, or putting excuses. I don't know if you, Rob, have seen.
Not from an IG club, no. I guess ultimately it comes down to a matter of cost and time. Securing a club LOU is very quick. It can be done within a matter of hours, as opposed to a bank guarantee, which can take days, which can take. Sorry. Yeah, sorry. So what I was saying is that it's really a matter of time and cost. So you can agree a club LOU within a matter of hours, whereas trying to agree wording with a bank guarantee can take days. And from a club's point of view, ultimately offering a club LOU doesn't really cost them anything, as opposed to if they have to put up a bank guarantee, then they have to pay that daily, monthly charge that the bank provides. So from both parties, it works better than a bank guarantee.
Exactly, Yaman. If we talk from a claimant's perspective, not from an owner perspective or a club perspective, according to our experience, I'm talking about Lebanon, when you have a bank guarantee and not a club LOU, always owners and clubs will come to you after maybe 6 months or a year at the latest, according to my experience, when we arrest and when you have a bank guarantee, and will offer settlements. Where you have a club letter, they will not come to you and talk about a settlement. So therefore, I'm talking about our jurisdiction and my experience. That's why we decided that, I had one time a case whereby I accepted the club letter, and this case is the only one not settled amicably. All the others, where we had the bank guarantee in place, were settled amicably within 6 or a year maximum, 6 months or a year. And this only case where we accepted the club letter is not settled yet, because the club or the owners, when they put a bank guarantee, they will be obliged to take the money, put them in another bank, pay the cost of the guarantee, pay the interest of the guarantee. Therefore, they will be compelled to come and tell you, please, let's settle. So this is why, in addition to this, in Lebanon, let's say for insurance's purpose, when you have a claim, the Ministry of Economy will tell you if you are covered by a bank guarantee is stronger than to be covered by a club letter. Yep. So we always, in our jurisdiction, I'm talking about, again, the claimant's point of view, not the owner's one. I appreciate what Rob says, that it's much easier to have a club letter. It takes maybe just some hours, and the bank guarantee will take much more time. But from a claimant perspective, it's much easier and much stronger when we request from the owners to submit a bank guarantee for the future settlement, amicable settlement of the claim.
Yeah, this is tactical move. Of course, even myself, I do this sometimes, so it depends on the case. But we're saying in general, if you have a genuine claim which is not yet quantified, which you think actually I need to sort out this as soon as possible and get this vessel out as a claimant, because you as well, being in the market, being a marine insurer, you have an interest to maintain good relations with these. If you were, for example, dealing with a Maersk vessel, you have an interest in actually helping them as well. Get your claim secured and let them go. And this is, of course, there is some cases, or each case will depend what tactical move as a lawyer you want to exercise. I'll give you an example. Sometimes an LOU would not respond to a liability of a charterer. So the LLU will say, if you get a judgment against X, against this party, I will pay you. If you insist on the claimant to put a bank guarantee in court, that bank guarantee may respond to any liability of the defendants. Yeah, so sometimes even if the bank guarantee says, like I had a case where the bank guarantee said, because it was badly worded, I will pay you if you obtain a judgment in this case. And the party who have put that bank guarantee was actually, the claim was rejected against him. Someone else was found liable, but that bank guarantee responded to that judgment. So you're right, sometimes it's the circumstances of the case will tactically, you'll say, no, I want a bank guarantee. But again, why I keep insisting on this is because what I've seen in this region, LOUs are not, honestly, and P&I structures is not local parties are not very familiar with clubs and with the structure and what can they do with these letters. Yeah.
Just two very quick points on that. One benefit is that sometimes when you, from a claimant's point of view, if time might be of the essence, if the vessel's discharging and she's going to be out of there within a day, you may, if you have to go to court, then because if you're looking for a bank guarantee, then that can take days and you won't have time to do that. So if you insist on a bank guarantee, then you'd have to go to court and arrest the vessel and then exchange the arrest, lift the arrest once the bank guarantee is given. Now, to do that in some jurisdictions, it's quite costly, and those fees are not recoverable, whereas in exchange for that, you can seek an LOU. And the second point is that actually the detriment to the P&I club is the fact that yes, they have to give the LOU, but they have to make a reserve for that every year in their books. So if the LOU is substantial, if it's millions of dollars, then they have to make a reserve every year in their book for that. So there is a negative impact on the P&I club. So that is leverage as if you would be leveraging a bank guarantee, i.e. the club would have to pay the costs of the bank guarantee, but with respect to an LOU, they still have to make the reserve. So both of those points are still pressure points when it comes to negotiating and trying to force pressure on the owner of the club to settle the claims.
Ziad, unfortunately I have to agree with you. Now, we all know that the P&I club, they will not proceed any further unless they have an actual threat that the vessel will not be able to sail after its discharge. Now, the bank guarantee can only represent the owner of the vessel or even the P&I club. They will never ever present a bank guarantee unless the vessel is arrested, and it's an only method, at least in our region, it's an only way is that to let the vessel leave and to replace the arrest itself by the bank guarantee. Unless you settle for any other security, or if the claim itself is settled. The problem with undertaking, especially after the vessel is arrested, is that you will start to negotiate after that with the P&I club once you have a final court judgment, especially with the amounts, and the P&I club might try to bargain with the final account and the final payment that they will pay you. And of course, also it will take a long time, as Ziad said, that it will take a very long time after the court or the claim court finishes. On the other hand, the bank guarantee, mostly the most important condition is that if you require a final judgment by the court, then you will be able to liquidate the bank guarantee immediately and literally speaking the second day. Now, in terms of whether the bank will be able to have the amount of money or not, this depends on the bank, and when one of your conditions for the P&I club is that you will ask him to provide you with first-class bank of guarantee, and by that you will ensure what Yaman addressed. So for me, if you have a vessel arrest, no, it's much better to have a bank guarantee than letter of undertaking, and also taking into consideration, very important, that letter of undertaking is not acceptable by the courts in most of our region, Jordan, Lebanon, Syria, and I think in the Gulf region also. For the courts, it's not acceptable unless, of course, you accept it yourself.
The only thing I'll add to that is that I disagree with respect to the ability to enforce, because a club LOU is just as good, if not better, than many first-class banks, particularly if it's from an IG club. And I've never known a club to challenge the validity or the value of an award. It's exactly the same terms as a bank guarantee in relation to once a final and binding judgment or award is presented to the P&I club. The P&I club will pay by return. They will not, I've never seen, and I can't believe a P&I club within the international group would challenge the validity and the value of an award. I don't know if Yaman's got anything to
No, Rob, what you say again is appreciated. We are not saying that the club will not honor the final judgment. It will honor a final judgment. What I'm saying that from a claimant's perspective, the clubs and owners are much more keen to settle amicably when there is money and where is cash and there is a bank guarantee. They will settle the claim within 6 months or 1 year. This is our experience. Yeah. While when you have a club letter and when they have only a reserve and not cash out of their pocket, paying the interest and the price and the value of the guarantee, it will push them to have a quick settlement. We are not saying that clubs will not honor their club letter. They will, definitely, but you will have to wait until you have a final judgment, which will take sometimes years. While when you have a bank guarantee and the claim is genuine and is just fine, so they will come and sit at the table and talk to you to liquidate the bank guarantee, stop paying the fees of it and the interest of it. Every time we have a bank guarantee in our jurisdictions, I'm talking about our experience, lawyers on the other side will come and tell you, Ziad, please let's settle. They will fight, maybe a little bit, and then they will tell you, we will have instructions, go and settle. While when you have a club letter, let's wait until the end. Let's wait until we have a final and irrevocable judgment to pay this LOU.
I mean, from your experience, that might be the case. But I think ultimately the money that a P&I or owner would have to pay for a bank guarantee is relatively nominal. And it's unlikely, from my view, that it would impact their view when it comes to settlement. If it's a bad claim that they are going to take a robust stance against, then they'll do that anyway, irrespective of whether an LOU is put up or a bank guarantee. So I'm not too sure how much impact that will ultimately have. Yes, if there's some issues with respect to the validity of the claim and it's in everyone's best interest to negotiate a settlement, which is typically the case in most cases, then it may have a small impact. But I'd be surprised if that was the overriding position of any club or owner when it came to settlement, that's like a key issue for them. I'm not sure if we've got anyone from the P&I club world in the audience, but
if we can break for now, our last session will be panel discussion, and one of our panelists will be Mr. Max Zakkar. He's the General Arab Insurance Federation chairman, and also he's very active member with IOMI. And if we have any question, we can maybe address it at the final open panel discussion, if you don't mind, because we are already 10 minutes overdue. Thank you. Thank you very much. Thank you very much. Thank you, Yaman. Thank you very much.
Hello again. At the end of our first session, we would like to thank both our distinguished speakers and the head of sessions for the insightful topics and presentations and knowledge. We kindly ask Mr. Robert Lawrence to deliver an honoring gift to our first speaker, Mr. John Barlow. Now we kindly ask Mr. Maher Hussein to deliver an honoring gift to our second speaker, Mr. Yaman Hawamdeh. Please join me in welcoming Mr. Majid Smirat, GIF Vice Chairman, to honor both head of sessions, Mr. Robert Lawrence and Mr. Maher Hussein. Mr. Maher. We now leave you with a small coffee break hosted by General Arab Insurance Federation, and we will resume the session at 12:30, where the topic will focus on enterprise risk management. Thank you very much.